Sometimes parties to a contract only want to pay if they're satisfied with the other's performance. These conditions of satisfaction create some special circumstances that we'll need to discuss. Let's begin by briefly reviewing what are conditions. Conditions are terms in a contract that are distinct from promises. A condition is an event not certain to occur, but which must occur unless its non occurrence is excused before performance under a contract becomes due. In other words, a condition serves to create or extinguish a contractual duty that would otherwise have been created by a promise. Offers usually propose an exchange of promises between parties. Sometimes those promises are subject to a condition. A condition makes a promise subject to an uncertain future event. Until that event occurs, the duty to perform that promise is not yet due. At some point, the failure of a condition to occur totally discharges the duty, such that it is never going to be due. Non-occurrence of a condition is generally not itself a breach, although in International Rotterdam we saw promissory conditions, which had features of both promises and conditions. The failure of those is a breach. We also saw that conditions can usually be waived, at least when they're minor. It's an equitable doctrine, so check your facts and circumstances. And that waiver can even be retracted, although circumstances for that are even more limited. In addition, courts in equity may excuse conditions to avoid forfeiture. Now we're going to talk about the specific case of conditions of satisfaction. Conditions of satisfaction are a particular kind of condition. Special rules apply to conditions of satisfaction, and we're going to cover those in this lesson. Conditions of satisfaction can be either subjective or objective, and we'll see that the objective standard is preferred while learning what the difference between the two are. Please keep in mind that conditions of satisfaction are always due to a duty of good faith and fair dealing. The duty of good faith and fair dealing pertains to all contract terms, so a party cannot, even if they're acting subjectively, claim that they are not satisfied when they're doing so in bad faith. Again, we'll come back to all those in just a minute. Let's review the restatement provision and begin with the rule on the matter. The rule is from Restatement Second of Contract, Section 228, which states, when it is a condition of the obligor's duty that he be satisfied with respect to the obligee's performance or with respect to something else, and it is practicable to determine whether a reasonable person in the position of the obligor would be satisfied, an interpretation is preferred under which the condition occurs if such a reasonable person in the position of the obligor would be satisfied. As you can see, the restatement here doesn't do very much to define what a condition of satisfaction is. Rather, it's focusing on the legal rule that we're going to prefer to find a condition of satisfaction is objective and judged by a reasonable person standard whenever possible. Let's clear up some terminology right off the bat. The restatement uses the term honest satisfaction to describe a subjective standard, meaning we're going to ask whether the person was actually satisfied. On the other hand, we see the term reasonable satisfaction used to refer to an objective approach. In the objective approach, when we look for reasonable satisfaction, we ask whether a person who was in like circumstances to the obligee would reasonably be satisfied. We don't actually inquire whether that particular obligee was actually satisfied. Rather, we take a more objective approach and ask what would a reasonable person think in like circumstances. If you've been with me for contract class this far, you probably won't be surprised to find that once again, contract law prefers an objective standard. In fact, contract formation is entirely based on an objective standard. It's only in contract interpretation that we start to see some level of subjectivity creep in. And even then, courts are very hesitant to admit subjective evidence. They tend to prefer objective evidence, and so we look to what a reasonable person would think in like circumstances whenever possible. Even when we use the honest satisfaction standard, and certainly when we use the reasonable satisfaction standard, satisfaction is subject to the duty of good faith and fair dealing. In fact, all terms and provisions in a contract are subject to the duty of good faith and fair dealing. As a result, a person cannot claim that they were not satisfied when they actually were. This makes a contract with a term for a condition of satisfaction not illusory. It might be illusory if a person could refuse to perform their obligations for any reason or no reason, whether they were satisfied or not. The duty of good faith and fair dealing, once again, helps us to have contracts where otherwise promises might be illusory. Let's take a look at how these standards apply with a couple of illustrations. In illustration 1, A grants to B an exclusive license in a designated territory to bottle and sell a soft drink on specified terms for a 5-year period. The contract describes in detail B's duty diligently to represent A in the territory and provides that A may terminate the license at any time if in A's sole, exclusive, and final judgment made in good faith, B does not perform that duty. After a year, A terminates, honestly telling B that in A's judgment, B didn't perform his duty under the contract. B has no claim against A, since A was being honest, and the agreement clearly provides for a test of honest satisfaction. Even though courts will prefer to use an objective approach when possible, they're not going to go beyond the intent of the parties where it is so patently obvious that they intended to have a subjective standard. Here we see contract language for a subjective standard in that A has the sole, exclusive, and final judgment, bound only by the duty of good faith. And since A honestly believed that B was not performing adequately and satisfactorily, A is able to discharge B. Let's look at a second illustration. A contracts to sell and B to buy 5,000 barrels of cherries in syrup, quote, quality to be satisfactory in buyer's honest judgment, delivery to be in installments. After delivery of and payment for a total of 100 of the 500 barrels, B states he is not satisfied and refuses to take any more. Since the agreement clearly provides for a test of honest satisfaction, it literally says buyer's honest judgment, B's termination is effective, so long as B's termination is in fact honest. If B was acting in accordance with good faith and fair dealing and honestly believed the cherries were not satisfactory, then B can terminate the contract. However, A can still show B's rejection was for other reasons. For example, B might have less demand on reselling the cherries, and so wants to avoid lost profits, even though the cherries are perfectly good. Or B might have found another supplier instead of A, who will deliver similar cherries at a lower price, and simply wants to pay less to make more profit. It's not in good faith to claim that the cherries A is selling are no good, when in reality they are good, but B wants to make more profit. A can potentially show that B is not, in fact, honestly satisfied, for example, by showing B expressed satisfaction with the first deliveries, or by showing circumstances such as B getting into a contract at a lower price for similar cherries, or B having sharply dropped demand on its resale of the cherries. In both of these illustrations, the contract clearly said that we are going to use a subjective standard. However, when the contract does not make it clear that it requires honest satisfaction and a subjective standard, it will not usually be assumed that the obligee has assumed the risk of the obligor's honest but unreasonable dissatisfaction. In such a case, in fact in most cases, and to the extent that it is practicable, we apply an objective test of reasonable satisfaction. Let's look at an illustration of where we apply reasonable satisfaction where possible. A contracts with B to install a heating system in B's factory for a price of $20,000 to be paid, quote, on condition of satisfactory completion. A installs the heating system, but B states he is not satisfied with it and refuses to pay. B gives no reason except that he does not approve of the heating system, and according to experts in the field, the system is entirely satisfactory. A does have a claim against B, since it is practicable to apply an objective test to the installation of a heating system. The interpretation is also preferred because it reduces A's risk of forfeiture. Note that this is a commercial contract for something which is inherently functional, and the question of satisfaction here seems quite measurable. There is an objective standard for whether a heating system works, for example, whether the building gets sufficiently warm. And we even have expert testimony in the field showing that this is a sufficient and satisfactory installation. Since we are able to apply an objective approach, and since there's nothing in the contract specifying that we have to use a subjective approach, we will apply the objective approach wherever possible. Let's look at two more illustrations. A contracts with B to paint a portrait of B's daughter, for which B promises to pay $5,000 if entirely satisfied. A paints the portrait, but B honestly states he is not satisfied with it and refuses to pay the $5,000. B gives him no reason except the portrait does not please him, and according to experts in the field, the portrait is an admirable work of art. Here, this is different from illustration 3. A has no claim against B, since it is not practicable to apply an objective test to the painting. Art and paintings are inherently subjective in a way that HVAC systems are not. When we have a contract for something like a portrait, and the parties have a satisfaction clause, there we will honor that satisfaction clause and look at it from a subjective viewpoint, because, as they say, beauty is in the eye of the beholder, and art is something meant to be beautiful, not just functional. In our last illustration, A contracts to have B furnish a 4-piece band to play at A's Inn for 6 months, with a provision. If the band proves unsatisfactory to A, contract is subject to 2 weeks' notice. A occasionally objects when B is absent, and a guitar is substituted for B's string bass. After 2 months, A gives notice of termination, stating that he is dissatisfied for this reason. B has no claim against A, since it is not practicable to apply an objective test to the band's performance. Music, like art, is subjective. Whether music is good or bad depends on the person's subjective viewpoints. There is no objective test for what is the best song ever or the best band ever. You could take a survey, but your personal opinion might change. Some people like country music, some people like rap, some people like string quartets. There isn't one best type of music, objectively speaking, in the same way that we can measure whether or not an HVAC system is raising the temperature of a room to 72 degrees. As a result, we're not going to apply an objective standard to something like art and music. Even though we would prefer to apply an objective standard wherever possible, it is not possible to apply the objective standard in cases where we have a satisfaction clause for something as personal and subjective as art or music. And here we will apply a subjective or honest approach to whether or not B has a claim against A. Let's look at the real-world case of Hutton v. Monogram Plus to see how courts will determine whether to apply a subjective or an objective standard. In this case, Hutton agreed to purchase a monogramming franchise from Monogram Plus Incorporated. And in the franchise contract, there was a clause that said Hutton could cancel his franchise agreement and receive a refund of his franchise fee if he was, quote, unable to obtain financing suitable to him within 90 days of signing the agreement. Note that suitable to him is similar to saying satisfactory to him, and so there is a condition of satisfaction that Hutton is able to get satisfactory financing. What did he need to finance? The primary cost was leasing the Monogram equipment, the Meistergram 800 XLC monogram machine. MPI offered terms for the lease of the equipment, but Hutton rejected them because they were substantially more expensive than advertised in some offering circular about the terms of the franchise. Hutton also tried to apply for financing from a bank, but it was rejected because Hutton had bad credit. He made a third application, which was rejected because of his insufficient collateral. Sounds like Hutton wasn't a very good borrower. Hutton subsequently requested a refund of the franchise fee, saying he wasn't satisfied with the franchise options presented to him by MPI, and noting that he was not able to get franchising from 2 other sources. MPI refused to give him his $25,000 back, so Hutton sued him. The appellate court concluded that the satisfaction clause is in a commercial context, and therefore would be understood as establishing an objective standard for satisfaction. Whether or not you like your financing is a lot like whether or not you like your HVAC system, and is fundamentally different from whether or not you like a portrait. The question, therefore, was whether a reasonable person in Hutton's circumstance would be satisfied by the offerings of financing by MPI, not whether Hutton himself was actually satisfied or honestly satisfied. That's what it means to have an objective standard. What would a reasonable person in like circumstances think, not what did this person actually think? The court said there was nothing unique about this commercial contract that would implicate a subjective assessment of Hutton's satisfaction. Indeed, this contract presents a classic example of an arm's length business transaction in which reasonable business concerns relevant to the financing of equipment dictated the terms of the contract. The court remanded back to the trial court for a factual inquiry into whether Hutton was, quote, unable to obtain financing objectively suitable for him. Likewise, we have another commercial context with a satisfaction condition in the case of Moore and Building Products Co. v. Baystone Construction Incorporated. In this case, General Motors, which makes the Chevrolet cars, hired Baystone to build an extension to a Chevrolet plant with aluminum siding. The contract said exterior siding of the walls must be of aluminum type 3003, not less than 18 B&B gauge, with a mill finish and stucco embossed surface and texture to match finish and texture of existing metal siding. All work shall be done subject to the final approval of the architect or owner's authorized agent, and his decision in matters relating to artistic effects shall be final, if within the contract documents. Should any dispute arise as to the quality or fitness of materials or workmanship, the decision as to acceptability shall rest strictly with the owner, based on the requirement that all work done or materials furnished shall be first class in every respect. What is usual or customary in erecting other buildings shall in no ways enter into the consideration or decision. Now, I read that quickly because it's long, but I want to key into a couple of odd aspects of this particular contract. First, this is a contract for the building of aluminum siding on a car factory, and it's discussing artistic effect. In addition, it does have language that seems to indicate that a subjective standard, a honesty in fact standard, applies here. For example, it says, the decision as to acceptability shall rest strictly with the owner. This is similar to other provisions we saw in the first illustration, where the parties clearly intended to have a subjective or honest satisfaction standard in their contract. Now, you probably can imagine the rest of the story. They built the siding, and the architect didn't think it was just the right amount of shininess. They didn't completely and totally match the shininess of the new aluminum to the shininess of the old aluminum when the sun was setting at a particular angle on particular times of the year. And they didn't want to pay for the building. There really wasn't an argument that the building was commercially, objectively satisfactory. But it sounded like the architect honestly didn't think it was shiny enough, or too shiny, or something. Anyway, the architect didn't like it. The issue on appeal, therefore, is whether the trial court gave a correct jury instruction, which quoted the contractual provision I just read to you, and then told the jury, quote, notwithstanding the apparent finality of the foregoing language, however, the general rule applying to satisfaction in the case of contracts for the construction of commercial buildings is that the satisfaction clause must be determined by objective criteria. Under this standard, the question is not whether the owner was satisfied in fact, but whether the owner as a reasonable person should have been satisfied with the materials and workmanship in question. So did the trial court get it right? Did they correctly disregard the plain meaning of the contract and impose an objective standard on this commercial arrangement? Recall the restatement which said, if it's practicable to determine whether a reasonable person in the position of the obligor would be satisfied, an interpretation is preferred under which the condition that the obligor be satisfied with the obligee's performance occurs if such a reasonable person in the position of the obligor would be satisfied. In other words, Section 228 says, we are going to use the objective standard wherever we reasonably can. Here, aluminum siding on a warehouse is purchased primarily, if not entirely, for commercial and not aesthetic purposes. Moreover, the sheen appeared fairly even in most lighting conditions. And moreover, it would be unreasonably difficult for Murin to have exactly matched GM's existing weather-worn aluminum exactly perfectly. I think the court here is raising a couple different issues. One is that they would really prefer the objective standard, and the second is they're not really sure that the refusal to accept this aluminum siding is in good faith. The appellate court determines that the jury had the correct instruction, and determined whether or not a reasonable person in GM's position should have been satisfied with the aluminum siding. So let's summarize. When do we apply an objective standard, and when do we apply a subjective standard to conditions of satisfaction? We apply an objective standard when the conditions of satisfaction have to deal with commercial value, commercial quality, operative fitness, fitness for a particular purpose, mechanical utility, relatively mechanical or routine contracts. In fact, we apply the objective standard whenever we can. It's preferred whenever practicable. When do we apply the subjective standard? When the contract is a matter of fancy, personal taste, aesthetics, when it inherently calls on judgment of an individual. We will only use the subjective standard when it is feasible to do so, when it is expressly called for in the contract, or when an objective standard itself is impracticable because they would have too many factors for a jury or a judge to really determine what is objectively satisfactory. And then second, once we've assessed which standard applies, how do they operate? If we are applying an objective standard, we simply ask, would a reasonable person in the position of the obligor be satisfied? If we apply the subjective standard, we instead ask, is the person in question actually satisfied in good faith? Are they honestly satisfied or not? Under the subjective standard, the promisor can avoid the contract so long as he is genuinely, albeit unreasonably, dissatisfied. And because we are hesitant with people avoiding contracts in this way, courts will try to apply an objective standard whenever possible. Thank you for joining me for this lesson on contract interpretation, conditions of satisfaction.